In this lecture, we consider the definitions of SLAPPs with reference to existing legislation, particularly in the United States, Canada and Australia, but also looking at the model Anti-SLAPP directive, which was devised by the Coalition Against SLAPPs in Europe. Our discussions focus particularly on how the law has evolved in jurisdictions outside the European Union, with a view to understanding the strengths and weaknesses of legislation adopted elsewhere, with a view to engaging with the different definitions and the effects which those different definitions have on the extent to which anti-SLAPP protections are available to SLAPP victims. Now, our discussions will begin with consideration of the origins of the term SLAPPs, the academic discussions in the United States around what SLAPPs are. We'll look at judicial acknowledgement of the existence of vexatious litigation intended to chill public participation, and then we'll look at a number of different jurisdictions in the United States, Australia and Canada, and finally the case model law, which, as you'll know, informed the proposed anti-SLAPP directive of the European Commission, which is currently being discussed by European Union institutions. Now, the term SLAPP, Strategic Lawsuit Against Public Participation, was coined by two American professors, Professor Pring and Professor Penelope Cannon, who essentially understood that there was a type of litigation which had the effect of chilling public participation. In analysing what constitutes a SLAPP, or rather which cases could properly be characterised as SLAPPs, these authors essentially, first of all, clarify that we don't need to look at what is the motivation of the claimant. We don't necessarily need to find that the claimant is acting in bad faith, nor do we necessarily have to find that the respondent is a good faith actor. As they put it, you can have SLAPPs brought by good people against bad people, but in either case there is a significant broader concern of the chilling effect of SLAPPs on public participation. So essentially, we're not looking to the character of the individuals concerned. What we're looking to is the key features identified at the bottom of this slide. Does the relevant action involve communication intended to influence governmental action? Is it a civil complaint or counterclaim? Is the respondent a non-governmental individual or organization? And is the relevant issue arising from a matter of public interest? Now, this is an academic definition for the purposes of their particular analysis of SLAPP cases. So these are the features they use to engage in a systematic study of existing court cases. This is not to say that, of course, we're dealing with a legal definition here. It is simply the manner in which they delimit their own study, but it is useful here to see that there are a number of important features which then are also visible in legislation, which we'll consider in a while. In particular, what we see is the difficulty when we try to engage with the motivation of the parties, and we'll see that legislation which does try to show an improper purpose of the claimant is problematic, because of course it is often hard to prove that improper purpose, and indeed you can have limitations of public participation even where there is no discernible improper purpose. We also see here that the key issue is that this is a question of involvement in public participation in the public interest, and that is the key marker. We'll see then that this is treated differently in different legal systems, of course, but it is useful to begin with Pring and Canaan, because of course they are the parents of this term, strategic lawsuits against public participation. Of course, the law may move in different directions to what they suggest, but this is where that terminology began. These authors note in their one of their several publications that the problem of SLAPPs has long been recognized in the United States. So they cite a judgment from 1981 in which the West Virginia Court of Appeals noted the specific problem of public debate being taken away from public fora, being taken away from the democratic space, and instead being made a matter of litigious adjudication, being made a matter for the courts rather than for the public space, rather than for the public to consider in a democratic process with no particular threat to either party. Essentially a competition of ideas turning into a legal competition with, of course, significant legal consequences for one party or the other. So as far back as 1981, the West Virginia Court of Appeals lamented the chilling effect which this would have on freedom of speech. The court says, "We shudder to think of the chill on freedom of speech and the right to petition if they were to allow the claim in question to proceed." Now that was 1981. Since then, several US states have now adopted anti-SLAPP statutes. So there are anti-SLAPP statutes in over half the states of the United States of America. The difficulty, however, is that these are all state-level legislative interventions. So what that means is that, of course, that while more than half of the states have anti-SLAPP statutes, the flip side of that is that almost half of the states in the United States of America do not have anti-SLAPP statutes. So immediately, simply by looking at the number of states that do have anti-SLAPP statutes and those which do not, the result is that there is a lot of room for SLAPP claimants to seek out a forum where there are no anti-SLAPP defenses. So ultimately, immediately there is plenty of room for forum shopping in the United States. But then even if we look at the states which do have anti-SLAPP statutes, there are significant differences. So in addition to these gaps in anti-SLAPP protection, there is also room for forum shopping because there is a significant degree of divergence in legislative protections. Some statutes cover only very limited subject matter. The remedies available to the respondent will vary, and the manner in which the courts have dealt with SLAPPs will vary from one jurisdiction to another, both because they may be instructed differently by the legislator, so the law may vary in the way in which it directs courts to determine whether a matter is a SLAPP and what remedies to provide, but also because the courts might consider constitutional protections in a different light and therefore conclude that the legislation should be applied differently. We'll look to a couple of examples to perhaps illustrate these differences in a little greater depth. And we find two examples by looking at the history of anti-SLAPP protections in the state of New York. So up to just a couple of years ago, anti-SLAPP protections in the state of New York were very, very limited. They were only available in respect of activities aimed at procuring favourable government action. Now that, of course, is problematic because ultimately it meant that media defendants were excluded in many cases from anti-SLAPP protections. And as you'll know, New York is the media capital, or certainly is arguably the media capital of the United States. And notwithstanding then the importance of the media to the state of New York, there were limited protections up to November 2020. That has changed through the introduction of broader protections, and the law in New York now addresses any communication in a place open to the public or a public forum in connection with an issue of public interest or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. And it goes on. What we see then is significant evolution in anti-SLAPP protections. And New York, of course, is not unique in this respect. Several other states in the United States began with very limited protections and latterly have introduced more robust statutes. We'll see in a moment, however, that of course there's always been one example which has been upheld as an example of good practice. But the example of New York is useful because, of course, you'll see lots of literature referring to how limited anti-SLAPP protections are in New York. Of course, that literature predates this very recent amendment to the law in New York, which provides now that that anti-SLAPP protections are available in respect of a broader array of subject matter. Now, the state of California, on the other hand, has for a long time been upheld as as the finest exemplar of anti-SLAPP protections. We'll see that that's not necessarily the case, or it's not necessarily the case that Californian law and practice are readily transposable in any other context. Nevertheless, it's important to consider the law of California because it is the most well-established system of anti-SLAPP protections, both in the United States and indeed globally. The system that is in place currently, even though also recently amended as of January 2023, that system remains very much intact as it has been for a long time and has been upheld as the finest and most well-developed system of anti-SLAPP protections, particularly because it has always focused on a broad array of issues and it has always had a clear system for how the courts are to consider whether a matter is a SLAPP and what they should then do if a matter is found to be a SLAPP. So lawsuits which are brought to chill the valid exercise of the right to free speech or the right to petition are essentially lawsuits which fall within the scope of the relevant provisions of the California Code of Civil Procedure. Then, in order to consider whether the remedy of early dismissal and indeed other remedies are available to the respondent in that case, excuse me, the California courts will consider, first of all, whether the matter concerns the exercise of the right to petition or free speech. So if it falls within the scope of the action on that basis, it will then look to whether the claimant has been able to show summarily that their claim has a probable will probably succeed in the court. So essentially they must show the probability of their claim's success through the consideration of affidavits of both parties and through the consideration of the balance of probability of whether the case will be able to go forward. Now, of course, what this does in practice is that it means that the anti-SLAPP hearing is really, in some ways, potentially a condensed hearing of the entire case. In any event, however, what it means is that there is a swift resolution of the matter rather than the more prolonged hearing which would otherwise happen. And indeed, of course, if it is found that it is not a SLAPP, the whole case will then go on to be considered in the normal way. But there is a degree of complexity, of course, in anti-SLAPP cases, whether in California or indeed anywhere else. They are a different type of hearing to the usual summary hearings with which courts are usually familiar, and they do require a significant degree of engagement with the evidence in order to consider whether a claim in the California system, or to consider whether the claim has that probability of success, whether the claim will possibly succeed if it goes to a full hearing. Now that's a very well established system, and one in which lawyers of course report some difficulties, but of course difficulties arise in any system, so we won't dwell on that too much, except to note, of course, that California is a common law jurisdiction. It is one in which judicial discretion is well understood. That system is not necessarily fully transposable in the European context without a degree of further elaboration and clarification to instruct civil law courts in the manner in which they should decide cases. We'll come to that later on when we look at the case model law. But before we get to that, let's look at a couple of other examples. In Australia, following the Guns case, there were several territories which considered the introduction of anti-SLAPP legislation, but legislative efforts were only actually successful in the Australian Capital Territory. It was found, it was decided there that the legislation would address a broad subject matter as well. So public participation, again, is defined in broad terms in the Australian Capital Territory legislation, the Protection of Public Participation Act 2008. But again, here there are some problems, and in particular, the claimant, sorry, the respondent rather, in a SLAPP case in the Australian Capital Territory would need to show that the plaintiff had an improper purpose to chill public participation. Now that's a difficult thing to show. You'll remember earlier on we saw that in the discussions of Pring and Canaan, and indeed in the legislation of some US states, there is no need to show this improper purpose. There is no need to look into the mind of the claimant to understand whether they intend to chill public participation. The fact that they do chill public participation is enough. But in the Australian Capital Territory, there is this need to show that improper purpose, that intention to chill public participation rather than to use the courts for legitimate purposes. And that, of course, makes it quite difficult to use anti-SLAPP protections. And it is therefore certainly arguable at a minimum that the Public Participation Act 2008 of the Australian Capital Territory is a somewhat problematic model which should not necessarily be looked at in a European context. We do find some good examples, however, in Canada. First of all, there is legislation in Ontario and British Columbia. So historically, British Columbia had anti-SLAPP legislation, then repealed it. In the interim, Ontario introduced legislation, and British Columbia pretty much adopted wholesale the Ontario legislation. So Ontario in 2015, then British Columbia in 2019, and Manitoba is currently considering a draft which is essentially identical to the British Columbia and Ontario legislation for all intents and purposes. Now, in Ontario, the legislation refers to what are called gag lawsuits. And those gag lawsuits cover a broad scope which addresses essentially any communication relating to a matter of public interest. So it's a really broad definition of the scope and isn't limited to particular types of communication to shape government action, for example, as historically was the case in New York and remains the case in some US states. In Ontario and British Columbia, a claim will be dismissed summarily unless the claimant can show that the action has substantial merit and that the respondent has no valid defence. And indeed, even if they can show that, they must show that the harm likely to be suffered by the claimant outweighs the interest of safeguarding free speech by not allowing the claim to go forward. So a claim will be dismissed early unless all of these things can be shown. Now, there have been studies in Ontario and British Columbia which show that this too is quite a complex business for courts and for lawyers. Essentially, this idea that lawyers really need to put their best foot forward in anti-SLAPP petitions, because you are really dealing with the complex evidence of the case at a very, very early stage. And in addition to that, you are dealing with the complex balance of rights between the claimant and the respondent, the complex balance of rights between the right to privacy and the right to freedom of speech in particular. So there's some criticism there, although of course there's also an understanding among lawyers in Ontario and British Columbia that this is a necessary consequence of the abbreviation of proceedings in anti-SLAPP cases, with a view to ensuring that the courts get it right at an early stage and do not allow proceedings to go forward, and therefore to chill public participation more generally if they are SLAPPs, if they are claims which do not satisfy the conditions identified on this slide, or indeed that the courts do not deny the right to access to courts in respect of legitimate claims which are of sufficient importance to be allowed to go forward themselves. So many lessons here to be taken from the experience in Ontario and British Columbia, and indeed, as we saw earlier, also in California, insofar as there is a degree of complexity in anti-SLAPP cases, and indeed a degree of specialism which develops in respect of anti-SLAPP cases. But again, here we're dealing with common law jurisdictions with a particular approach to lawmaking, which is perhaps not entirely consistent with the approach adopted in most continental European states. On the other hand, we find an example of legislative style which is quite useful from a European perspective in Quebec, which of course has a mixed legal tradition, originally very much of the French school. The Quebec legislation again provides a broad definition of SLAPPs, but also includes a couple of very useful innovations, or at least at the time of its adoption, these were innovations compared to several other jurisdictions. First of all, insofar as the manner in which anti-SLAPP proceedings begin. Now, you'll have seen in much of the other legislation that we've considered that what is required is that the respondent request that the court dismiss a case early, at an early stage. In Quebec, the respondent is able to apply for early dismissal of a claim, but also the court has the right ex officio to dismiss a claim at an early stage. So anti-SLAPP remedies can be provided by the court of its own initiative, or of course the respondent can request that the court consider whether the claim should be taken forward. What we find also, however, in the Quebec legislation is a very clear articulation of what is a SLAPP and what process the courts should consider. So first of all, the legislation begins by showing very clearly that the intent of the claimant is not relevant, regardless of intent. It then goes on to explain that abuse of procedure can include both the fact that a claim is unfounded or is frivolous or is intended to delay the court proceedings and therefore to maximize cost, or if there is conduct which is vexatious or quarrelsome. And indeed there can be excessive or unreasonable procedures or broader designs to prejudice the respondent to defeat the ends of justice and to chill freedom of expression. So this is a very refined definition. There's a lot to chew on in this definition, but also it's very much of that civil law tradition, providing a full definition, which then merits further attention, particularly insofar as the right of the courts to dismiss claims ex officio is concerned, the exclusion of the need to show that abusive purpose of the claimant, and rather determining this question with reference to objective criteria. And we see that then again in the models which NGOs in the European Union have put forward for consideration by legislators by the legislators here, particularly the Commission. The case model directive draws very much on this good practice from those jurisdictions which we've seen, including Quebec, insofar as the structure is concerned, but of course also the experience of lawyers in the United States, Canada, and Australia, and however notes the differences in European legal systems and uses both language and structure which is more familiar to those legal systems. Now, it's important to consider the model directive because, of course, this is what was presented to the European Commission before the legislation started to be developed in the EU, and it also provided the basis for discussion among experts with whom the Commission consulted. Now, the model directive refers to the term abusive lawsuit against public participation because, of course, that then excludes the need to show a strategy by the claimant. All we need to show is abuse. And that abuse will be identified then in a moment on our next slide. Now, these are claims which, first of all, must, of course, be concerned with the defendant's public participation on matters of public interest. So it doesn't matter under this definition whether it's a civil or commercial cause of action, or indeed whether it's a criminal cause of action in the case model directive, although as you'll know, criminal cases are excluded from the Commission's proposed anti-SLAPP directive. And in any event, when the claim concerns a defendant's public participation on matters of public interest, it will be considered to be a SLAPP either because it lacks legal merits or is manifestly unfounded, or if there are other elements of abuse. So this is a similar idea to what we just saw in the Quebec legislation, which identifies different routes. It's not only a claim being unfounded or lacking merits, it's also other elements of abuse which could give rise to a finding that a claim is indeed a SLAPP. The model directive then provides a helpful list of what constitutes a potential abuse and invites courts to consider a number of different factors. And you'll see here echoes of those different laws which we looked at on previous slides. So the prospects of success of the claim, whether the claim is disproportionate, excessive, or unreasonable, the balance of rights of the parties, the litigation tactics employed by the parties, the costs of proceedings, the imbalance of power, and so on and so forth. And crucially, of course, both the actual or potential chilling effect on public participation. Now, this is a model directive. It isn't actually the law of the European Union, of course. The proposed law of the European Union is considered on another slide. But it's worth considering here that there are a number of different factors which the case proposal, the Coalition Against SLAPPs in Europe proposal, asks courts to consider in determining whether a case is in fact abusive, a claim is in fact abusive. This too would of course be a complex consideration, a complex discussion to take place in court in order to have that summary dismissal, in order to have those anti-SLAPP remedies. But of course the structure here is non-exhaustive. It's a list which the courts will consider and which will guide the court's consideration of the balance of interests in the particular case in question. You can of course consider this in your own time and read the model directive to look at these different features. But of course what's really crucial here is that we understand that what we have here is a condensation of all of that knowledge taken from other jurisdictions and presented as a potential model in a systematic fashion for the European Union. And we'll see in subsequent recordings, of course, that this has helped to shape how the European Commission drafted legislation for the European Union. So the European legislation, which we'll consider in other recordings, draws on the experience of these other jurisdictions, draws on an understanding of the strengths and weaknesses of those other jurisdictions, and draws on this research conducted by and on behalf of NGOs to ensure that there is a sound research basis for the development of European Union law. That concludes our discussion at this stage. In other discussions, of course, we'll look at the the proposed EU directive itself. We'll look at existing EU instruments, and we'll also consider the fundamental rights considerations which are relevant to SLAPP suits. Thank you.